What I'm telling you is I don't do or lift no contact orders unless I get a chance to speak to the complainant.
All right, folks, buckle up, because what you're about to watch is a case that blends alcohol, accusations, and a protective order that could change everything for this defendant. We've got Francis Marie Oliva, charged with harassment of a public servant, a third-degree felony that carries some serious weight, up to 10 years in prison and thousands in fines. But instead of a jury trial, Francis is chasing deferred adjudication, a kind of legal second chance that lets her avoid a conviction if she plays by the rules. Sounds simple, right? Well, not so fast. The judge makes it crystal clear. If Francis slips up even once, that deferred deal vanishes, and she could be staring down hard time. Now, what makes this hearing even more intense is the drama underneath. A toxic relationship, alcohol, and whether Francis can convince the court she's truly ready to change. Keep watching, because by the end of this, the judge delivers a decision that flips the whole tone of the case.
All right, the court is calling 2025 CR 00890, State versus Francis Marie Oliva. Can I have parties announced?
Lauren Espinoza for the state.
Rebecca Alex for defense.
And are you Francis Oliva?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Oliva, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it? Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment? State, are you proceeding on the indictment as presented?
Yes, sir.
Ms. Oliva, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? You're charged with harassment of a public servant as a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison.
Let's pause here. What the judge is laying out is a legal tightrope. Deferred adjudication may sound like mercy, but it's actually a contract with serious teeth. If Francis violates probation, she won't just face a slap on the wrist. She could be sentenced to the full maximum penalty for harassment of a public servant, which is 10 years. Think of it like being given a key to avoid prison, but if you lose it, the door slams shut harder than before. Question for you guys. If you were in her shoes, would you risk deferred adjudication knowing the consequences, or would you roll the dice with a jury trial?
And up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine? Counsel, has your client been able to provide you with any defenses? Do you believe she has a rational as well as a factual understanding of the charges against her? Do you believe she's currently competent and was legally sane at the time of the offense? Ms. Oliva, sorry.
It's okay, it happens all the time.
I've been working on my Spanish. I'm doing the best I can. Okay. All right. Well, I'm doing great then. All right. Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with the your attorney? Did you understand it? According to the plea, there's a $2,000 fine and state recommends deferred adjudication. Did you understand that to be the plea?
Yes.
Defense? State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 8 years.
Here's where negotiations get interesting. The state isn't just asking for deferred adjudication, they're recommending 8 years of it, with strict conditions, substance abuse evaluation, 200 hours of community service, and even restrictions on what jobs Francis can hold. This isn't just punishment, it's rehabilitation by design. Notice, too, the alcohol angle is central. Courts often use probation terms like random drug tests and alcohol bans because even one drink could be seen as a violation. It raises a bigger question. Are these conditions genuinely meant to help offenders rebuild, or do they set people up to fail? Drop your thoughts below.
There'll be a TAP evaluation and 200 hours of community service restitution. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor, state offer states exhibit 1 in all attachments.
No objection.
All right. Did you review the waiver document with your attorney? Did you understand it and sign it in all the appropriate places? Again, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent. Did you understand? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yeah.
Anything you wish to say on behalf of your client?
Yes, it's probably good.
All right. So are you still with or living with Ariel Gutierrez?
Living in the studio 6 hotel with my son.
City of where?
Studio 6 with my son.
Oh, okay. Studio 6, that's a place, not a, oh, okay. Okay.
Provides a kitchen and everything that I need to cook food for him.
Okay. And are you employed?
Yes, ma'am, I'm full-time with the Circle K. I'm actually about to be a manager for them.
Well, congratulations. It appears that this was a bad night for you.
In all honesty, it's supposed to be a great day celebrating my wife going into school.
Mhm.
And
Well-
about an hour and a half later, that's happened.
Yeah, nothing good happens at a certain point. And sometimes for every celebration, you don't need alcohol.
I agree with 1,000%. My wife has never been drunk a day in her life, and she wanted to experience it. She's also a culinary chef, so
Okay.
it's started experiencing it.
Ah. So here's the thing. I've learned never say 1,000% because it's not true. Whenever you watch Maury Povich, when people are doing the DNA test to determine if somebody's the father, anytime somebody says, I'm 1,000% sure he's the father, guess what it comes back? You are not the father. And it's because when you go past 100%, you're just trying to sell it now.
Yeah.
So just keep it at 100.
It's plain thinking. I really don't. I only did it because my wife is really getting drunk.
And here it is, the moment that hits hardest. Francis tries to explain that alcohol was tied to the incident, even joking about percentages and DNA shows. But the judge doesn't flinch. While you're on probation, no alcohol. Period. This is a standard but crucial condition. Judges know that alcohol fuels poor decisions and repeat offenses, so they cut it off at the source. But here's the irony. Francis's wife had never been drunk before, and this whole spiral started with what was supposed to be a fun experience. From celebration to probation, one night of drinking flipped her entire future. Ever seen a night out snowball into something this serious?
Oh, wow. Well, that's a no.
She had never been drunk a day in her life, so she wanted to experience it at the age of 30.
Okay. Well, here's the thing. While you're on probation, you're not allowed to drink alcohol. It's not allowed, okay? All right, so this is what the court is going to do. There's a $2,000 fine. It will be probated. Regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. 200 hours of community service restitution. I'm going to order parenting classes. Once that's completed, the community service hours will be deemed satisfied. Field visits 1 time per month until further notice. And does she have any criminal history other than this? And what would that be? All right.
Then I get finished probation fully.
All right, any felonies? Do you have any felonies?
Not really. So it was for that truck as well.
Okay,
Again, I did finish my probation. I had to leave my probation officer because I was due to get off the list early.
This is another huge twist. The judge orders Francis to have no contact with Ariel Gutierrez, the complainant. Francis insists they're separated but still hints she wants contact. Here's the legal reasoning. Protective and no contact orders exist to shield victims, even if they reconcile later. Judges won't lift those orders without speaking directly to the complainant to ensure there's no intimidation or lingering fear. It's a safeguard, but it also creates a dilemma. What happens when both parties want reconciliation, but the law says not yet? Should the judge prioritize the complainant's stated wishes or their protection even against their own choices?
all right. I'm going to sentence you to 4 years deferred adjudication. There's to be no contact with Ariel Gutierrez. You said you all are not together anymore.
Still, like, we've been separated this whole time. For this, but I'm hoping to get contact back with her because she's really the person who has been helping me. Yeah, that's the reason.
Well,
why.
you all will have to come to me showing me that there's no longer a protective order in place. And then for incidents such as these, I want to speak to that person and make sure that they are not in fear. That's what I have to do to protect the community. So you'll need to talk to probation about that, then probation can come to me. But for now, no contact. You understand what you need to do in order to have contact?
And there it is, the ruling. 4 years of deferred adjudication, strict probation conditions, no alcohol, community service, parenting classes, and no contact with Ariel until the judge is satisfied it's safe. Some might see this as lenient. Francis avoids a felony conviction and prison time. Others may think it's a ticking time bomb, with so many conditions stacked against her. One slip, one bad night, one ignored probation call, and it all collapses. This case perfectly shows how the justice system balances accountability with rehabilitation, but also how fragile second chances really are.
Talk to your attorney. What I'm telling you is I don't do or lift no contact orders unless I get a chance to speak to the complainant. And I understand that this was involving alcohol, but there was a lot going on. Probation, is there anything else?
Judge, did you want that top evaluation completed?
We can do TAP evaluation out of custody.
Okay, Judge, nothing else.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. All right, and that we can go out the record in this court. Communication is key to be successful on probation. If you have an issue, let probation know about it. If you feel they're not addressing it, you can always come back to court. All right, thank you.
So let's recap. Francis Marie Oliva was facing a felony charge with prison time on the table. Instead, she walked out with deferred adjudication, a deal that gives her a clean record if she completes 4 years of probation. But the rules are strict. No alcohol, 200 hours of community service, mandatory parenting classes, and absolutely no contact with Ariel Gutierrez without court approval. This wasn't just about punishment, it was about control, safety, and testing whether Francis can really rebuild her life under pressure. What do you think? Was this a fair outcome, or did the judge go too soft? Let us know in the comments. And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Until next time, stay tuned for more cases that prove just how unpredictable the justice system can be.